Good afternoon, everyone. We've hit noon, and so I'm going to get things started. My name is Jackson Soames, and I'm an associate with Schoeneck King. I want to welcome everyone to the fifth installment of a multi-part series hosted by Schoeneck King on New York State's Medicaid compliance program. For this installment, we are happy to feature representatives from the New York State Office of the Medicaid Inspector General, as well as the Medicaid Fraud Control Unit of the New York State Attorney General's Office. Each of the prior installments of this series are available on the BOMD website, bsk.com. And in today's programming, the speakers will discuss their office's collaboration, as well as the distinct roles and responsibilities each office plays in protecting New York State's Medicaid program. And this includes conducting audits and investigations, the recovery of overpayments, and recommending managed care contractual and other program integrity requirements. Now, the speakers we have today are Michael D'Allard, the Deputy Medicaid Inspector General for the OMIG's Division of Medicaid Audit, and Sherry Brown, Senior Counsel for Civil Enforcement at the Medicaid Fraud Control Unit, which is the largest unit within the New York State Attorney General's Criminal Justice Division. After the presentation by our speakers, the program will close with a Q&A session moderated by Bond Attorney Gabe Oberfield and OMIG Director of Public Affairs Bill Schwartz. We received many questions in advance, and we will answer those questions during the Q&A session. If you have any additional questions that come up during the presentation, please feel free to enter them in the chat, and our speakers will address those as best they can. Any questions entered in the chat that we don't answer during this webinar will be collected and sent to our speakers for their review, and we will circulate those answers afterwards. In addition, this webinar is being recorded and will be shared afterwards. It will also be available along with the 4 other previous installments on the Bond website. Once again, that's bsk.com. Now, before we get to our speakers, I want to turn it over to Bill Schwartz, who has some quick words.
Thank you, Jackson. Thank you, Gabe. First and foremost, I want to thank Schoeneck King for providing yet another opportunity for us to address his client base and the provider community that's here with us today. Just a couple of quick points. Obviously, OMIG cannot speak to any matters, and I'm sure I speak for Sherry as well, any matters that are open in terms of audits, compliance reviews, self-disclosures. Certainly we want to touch on matters of importance, but we certainly can't talk to anything that isn't an open status. And secondly, the comments made today by the speakers reflect those individuals, not their respective agencies. So that's out of the way, but I just wanted to take 1 second and again, thank you for participating. And I mean that sincerely. I speak on behalf of OMIG when I say that these opportunities are vital for us because it is a collective effort that we're engaged in here, provider community, oversight agencies, because the bottom line is at the end of all of these regulations and everything else, there are recipients. And that's what drives us. What we enforce is in the best interest. That's our goal, is to serve the Medicaid recipients and to ensure that this program, the Medicaid program, New York's robust, high-quality program, is sustainable. And health and welfare of some of the most vulnerable people in the state, those are the stakes. We know you know that, and we want to work closely with you. So when I say it's a collective effort, that's what these programs are all about. We hope to share with you today some information that you find is helpful. And at the end of this program, we want this to be an ongoing engagement. You're going to hear about how to contact us if you have concerns. But beyond those, contact us if you have questions, if you have insights. It informs our work. So it's vitally important that we keep this dialogue going. So with that, I want to thank you again all for participating, and in particular, Schoeneck King for providing these really valuable opportunities. Thank you very much and enjoy the program.
Thank you, Bill. Appreciate the introduction there. And also appreciate the opportunity to speak here today. I will offer a brief introduction on the role of OMIG, and then I think Sherry will probably provide a similar introduction regarding the Medicaid Fraud Control Unit. So I think, as probably most folks are aware, OMIG is an independent office within the Department of Health. Our role is the prevention and detection of fraud, waste, and abuse, and the recovery of improperly expended Medicaid funds. In carrying out our responsibilities, OMIG conducts audits and investigations. Sometimes you'll also hear the term conducting reviews, most commonly in conjunction with, for example, compliance program reviews, which I'm sure have been spoken to in earlier sessions. Let me just touch on a bit sort of the difference between an audit and investigation. So an investigation will generally begin with some specific allegation of wrongdoing. And in the course of conducting that investigation, that's going to generally result in either the allegation being found to be unsubstantiated, or it could lead to a finding of unacceptable practices, impositions of sanctions, or monetary penalties. In addition to that, it could also result in referral to the Medicaid Fraud Control Unit if we find suspected fraud within the program. On the other hand, audits are conducted to assess provider compliance with Medicaid program integrity statutes, as well as the regulations and directives of the department and other relevant state agencies. And these are done to identify and resolve deficiencies, recover associated overpayments, and ensure that Medicaid recipients have appropriate access to quality medical services, that those services are documented and billed appropriately, and that program requirements are adhered to. I'll just offer a little bit more color around the audit process, particularly in my role as deputy for audit. The audit procedures we follow are set out in state regulations, 18 NYCR Part 517. They're conducted in a manner where we hope to foster communication with all providers throughout the engagement to resolve findings. Providers are always encouraged to submit all documentation to support the appropriateness of claims, and we review all submitted documentation. We want the process to be collaborative and encourage providers to remain engaged throughout. Where documentation is found to be out of compliance, then in those instances, as a result of the audit, OMIG would identify and recover the associated Medicaid overpayments. And as a reminder, we also have available on our website protocols which we've created with the relevant state agencies and provider community with respect to the application of Medicaid requirements as part of our audit procedures. You know, more broadly, what I'll just say is that where we are conducting our audits, whether it's an audit or an investigation, it can result in if those audits or investigations uncovered potential fraud or abuse. Unacceptable practices is another term under our regs for that. It could result in not just the recovery of overpayments, but also the imposition of sanctions. So censure or warning under the program, exclusion from the Medicaid program, or imposition of monetary penalties in conjunction with that, in addition to the recovery of any identified overpayments. If the conduct rises to the level of suspected criminal fraud or is a credible allegation of fraud under federal law, then we are required to refer such matters to Sherry, Medicaid Fraud Control Unit, and may need to take other actions in conjunction with that. With that, Sherry, I will turn it over to you for anything you want to add with respect to MFCU.
Good morning and good afternoon. Thanks for having me. My name again is Sherry Brown, and I'm speaking informally to you, as was the disclaimer at the beginning today. The main message I want to convey initially is that we actually appreciate providers who are doing their best to deter fraud and abuse in their own programs and to act as their own vigilant personnel to make sure everything is going the way it should. I assume most of you became involved in the care industry and trying to help people because you want to do the right thing. Unfortunately, we find that sometimes greed or other factors can interfere with that. And you as providers can do an awful lot to detect that up front and to refer as appropriate. My office typically gets complaints from whistleblowers. We will get referrals from OMIG or other agencies. And we also have a very active, independent investigative arm within our own unit where we uncover issues we need to investigate. So we're always happy to get referrals or information about matters of concern. At the end of the PowerPoint, we will have the email addresses for referrals to both my agency and to Mike's. My agency has a way to make referrals for potential fraud or reasonably suspected fraud or criminal activity, and also for just general complaints that would go to another part of my office. If we could just go to the first few slides, I wanted to briefly talk about the certification. I believe that everyone who's attending today is familiar with the certification statement for provider billing Medicaid, but it's always helpful to just quickly remind you how important this is. And almost you could view it as a daily vitamin. Think about this when you're providing care on a day-to-day basis. We can go to the next slide. The next slide shows that the certification has these words. A partner, officer, or director of your provider is certifying annually that they're going to basically do the right thing. They're going to make sure people have the right services, that the people providing them are appropriately licensed and trained, have the experience, that your provider is furnishing or causing to be furnishing the care services and supplies, and have done so mindful and in accordance with applicable federal and state laws and regulations. You're familiar with the provider manual, revisions to it. Claims for care services and supplies are provided at the order of another, have been ordered to your best belief based on medical necessity and in compliance with requirements. And nothing is being covered by another payer, so that Medicaid, who is the payer of last resort, is not paying for something it should not. And you're not going to resubmit claims for things that have already been paid for. If you could just turn to the next page. The certification continues with these mindful comments that you certify to, that when you submit this claim, every claim you submit for the year and until you execute the next certification is accurate to the best of your provider's understanding. And significantly, no material fact has been admitted, and that you understand the source of the money you're receiving is from federal, state, and local funds. And you do remain subject to fines, prosecutions, and other liability under federal and state laws. Importantly, records pertaining to care and supplies need to be maintained for at least 6 years. Some of you may also be providers to manage care plans. If so, those plans and their subcontractors are also subject to 10 years. So I just wanted to relay that as a reminder that if for any reason your provider is asked for records, it's helpful to retain them. And also in New York State, the state finance law contains a False Claims Act provision, and that does allow my office to bring cases going back 10 years. So I highly encourage, conscientious providers to keep your records for 10 years, because it will then be easier to respond to inquiries. And it also, I think, will improve your own practices. With so many things being electronic today, you're not bearing the burden of what we used to see in the past, giant rooms with boxes everywhere. If you go to the next page. So this is also part of the certification, what the senior person at your office is certifying to. And this certification, if you can go to the next page, is ultimately executed before a notary public every year. And if you can go to the next page, and this is the instructions, I won't belabor that. And the next page, please. There is also a participating provider certification that your provider may be executing if you are a provider and have an agreement with a managed care organization. If so, you should be executing this as well. And this document should be sent directly to the MCO, who can provide it upon request to my office. If you could go to the next page. The key parts of this, in terms of what the certification is, are on the screen now. That you understand you're subject to the statutes, rules, regulations, and applicable Medicaid updates of the program, DOH, and all the rest of the language here about related to the furnishing of care, and that all care services or medical supplies for which the provider submits claims for have been provided, and that payment requests are submitted in accordance with applicable law. If you could go to the next page. And this ultimately is the rest of the certification where the signature appears. Mike, do you have any comments on this part?
I would just emphasize the importance of making sure that you are reading, when completing these certifications. Certainly the one that Sherry has on the screen now is one that is going, and I believe being submitted and held by the managed care plans. The ETIN that she showed earlier is being submitted directly to the department. Certainly reading and being familiar and understanding those certifications, I think, is always important. As both Sherry and our office will expect compliance with all the requirements that are outlined in the certifications that are being completed.
Thank you, Mike. Would you like to talk about the obligation to return overpayments?
Sure. Why don't we, before that, maybe talk a little bit about how our two organizations work together?
Sure.
So, OMIG and MFCU both have obligations to coordinate our activities with one another. There's a certain amount of crossover, particularly where OMIG is opening and conducting preliminary investigations and making referrals to the Medicaid Fraud Control Unit. We have obligations under federal law, for example, to implement payment suspensions if there's a credible allegation of fraud, but that requires coordination on timing and other issues with Sherry and her team. So as a result, we're in fairly regular communication with one another. The federal regs talk about the need for both OMIG and for MFCU to be talking to one another, to be actively engaged in sharing documentation and other data that MFCU might need to support its law enforcement activities. We also work, Sherry and I particularly, very closely together on model contracts for the Medicaid managed care program and ensuring that the health plans are in compliance with federal law governing and protecting the program integrity for Medicaid, and ensuring there's appropriate safeguards that the plans are carrying out and requiring their network providers and subcontractors to meet. One of which is one such requirement that kind of came out of that is the certification that's on the screen. I don't know, Sherry, if there's other things you'd like to cover addressing our coordination.
Just basically, if there's a referral by Mike's agency, OMIG, to us, we will look at it. We will ask for the documents they've received. We may ask for interviews they've conducted or any audit materials they've conducted. I probably should have stepped back, Mike, and just explain what MFCU does. Just briefly, so everyone understands what our authority is and what we do. So our authority is federal in nature. And basically, we are here to conduct statewide program for the investigation of prosecution of violations of all applicable state laws and all aspects of fraud in connection with any aspect of medical assistance and the activities of providers. And we can also actually, with approval of the Inspector General of a relevant federal agency, look at other aspects of healthcare services and activities of providers. And in particular, our authorities in a section called 42 USC 1396B, and also the regs, 42 CFR 1011. So just to quickly go through that so you understand our scope, we can investigate and prosecute or refer for prosecution violations, including for criminal statutes, civil false claims statutes, excuse me for a minute. And we can review complaints of abuse or neglect of patients, of residents in healthcare facilities receiving payments under Medicaid. We can also review complaints about misappropriation of patient funds or residents of facilities. And we can also investigate outside of this, even if, for example, with nursing homes, the person is not a Medicaid enrollee. And if the initial review of the complaint indicates a potential for criminal prosecution, we'll further investigate in that way or refer to an appropriate criminal investigative or prosecutorial entity. And if we discover that overpayments have been made to a healthcare facility or another provider, we can recover such overpayment as part of our resolution of a case, and do whatever we can. And OMIG and no official of OMIG has authority to review the activities of our unit independently or to review or overrule the referral of a suspected criminal violation to an appropriate prosecution authority. And Mike, do you want to talk about your referral obligations anymore, or did you say enough on it?
I mean, I think we've covered it, or I've covered it in
Okay.
the sense that we are obligated. There's state law requires us to refer suspected criminal fraud to the Medicaid Fraud Control Unit. Federal regs use slightly different terminology, suspected fraud or credible allegation of fraud. Sort of the difference between fraud and abuse. Abuse are practices that are inconsistent with sound fiscal medical practices. Fraud has an element of intent, though Mafuku, I believe, Sherry, is not necessarily specifically limited to needing to always prove intent, if I have that correct. I think reckless disregard is a...
Yes, thank you, Mike. For example, in the federal regulations under 1007.1, fraud is defined as any act that constitutes criminal or civil fraud under applicable state law. The conduct may include deception, concealment of material fact, or misrepresentations made intentionally, in deliberate ignorance of the truth, or in reckless disregard of the truth. And also, I just wanted to briefly comment on neglected patients. Neglected patients or residents means any act that constitutes neglect of a patient or resident of a healthcare facility or boarding care facility under applicable state law. This can include the failure to provide goods and services necessary to avoid physical harm, mental anguish, or mental illness.
Sure.
Mike, and Sherry, if I might intervene for a second, I thought it might be good in the interest of time, and I know there'll be questions, but I think an important point is the distinction between audits and investigations, Mike, and also because this is part of an ongoing series on compliance and self-disclosure, perhaps you folks, both of you, can get into some of the risks and benefits of those aspects. I think that would be helpful to touch on. Thank you.
That's a good point. Bill, thank you. So in promulgating the amendments to 521 back in 2022, one of the things that was certainly from the OMIG perspective we recognize is that compliance, self-disclosure, there's some connection back to audit and investigative activities to a certain extent. An effective compliance program is one that should be protecting Medicaid recipients to ensure they receive appropriate care, safeguarding federal and state funds, identify and correct issues early, self-disclosing overpayments, and therefore reducing the potential financial exposure in an OMIG audit. And certainly, I would also add that if an issue rises to the level of abuse, again, the sort of conduct that is not per se fraudulent, but a little bit of a lower standard, then having an effective compliance program and self-disclosing overpayments, demonstrating that through compliance reviews and self-disclosures are things that OMIG could consider as a mitigating factor where we're considering any potential sanctions or penalties associated with unacceptable practices. So I think that to some extent is some of the benefits associated with an effective compliance program. In terms of risks, you certainly have patient harm, sort of the inverse, the risk of OMIG audits resulting in higher overpayment findings or potential liability, unacceptable practices, and imposition of more severe sanctions or penalties. And then I know there's certainly things on the other side, Sherry, from a false claim or Medicaid Fraud Control Unit potential action there. I don't know if you want to touch on any benefits or risks that you see on your side.
Well, we're really very interested in having you make referrals to us if you think it's potential fraud or reasonably suspected criminal activity. Because we can jump on it, especially if someone's facing potential harm. It's really important to get to us as soon as you can. And Kathy, if you could just scroll quickly to the last slide in the PowerPoint. Right after that, here is information where you can actually make referrals to MFCU and also to the Attorney General's office and also to OMIG. I just wanted to go back, and I should have mentioned on the certification that everyone does execute. You also are saying that you've adopted and implemented, where applicable, an effective compliance program pursuant to social service law requirements, and you've satisfied the applicable requirements. And just going back quickly to the audit point, my office also may conduct an audit as part of our investigation of other matters. And if so, we're not limited to the criteria we may employ. We may also use data analytics. Some of our cases actually may be nationwide because other states may have an investigation against the same provider. That is more typical if the provider obviously is in other states at the same time, and if there's a whistleblower key TAM action filed. And we really do appreciate the self-disclosures also that Mike is referring to. I would just, make the point, if a provider does know it's under investigation by MFCU, the Medicaid Fraud Control Unit, it's not a good idea to refer to OMIG as if that's not happening without disclosing that. And it's not a good idea to minimize what you're disclosing or the time period of it. You should be in direct contact with MFCU if you as a provider are under investigation, and that's not a way to make the issue go away. We can, even if OMIG is making a recovery pursuant to an audit and other factors come to our attention, we have the ability under the False Claims Act to seek treble damages. And criminal prosecution as well. And Mike can also tell about other penalties that are faced. But the whole idea of meeting with you today is actually to say we don't want anything to get to that level. If providers could cooperate and make referrals to us and cooperate with our investigations, it goes a long way. Mike, please comment.
Yeah, let me speak a little bit to the self-disclosure requirements.
Thank you.
Which I'm sure folks are certainly familiar with. Certainly under both state and federal law, began with a requirement that was passed as part of the Affordable Care Act, I think in 2010. Persons in receipt of Medicaid overpayments have an obligation to report, return, and explain. Both federal and state law require those overpayments to be returned within 60 days of identification for most types of payments. There's also, if it's cost-based, then it would be related to when the cost report is due. I think from an audit perspective, part of having an effective compliance program is using the results of state and federal audits to identify potential risks and implement corrective action. So I know that the concept of that is captured within subpart 521-1 for the compliance program. And part of that, I think an important point to keep in mind is part of taking corrective action should include reviewing the results of OMIG audits, which may offer credible information that a provider is in receipt of an overpayment. That's beyond the scope of whatever OMIG's audit period was, or the Medicaid Fraud Control Unit for that matter. So if OMIG's looking at an audit period of 2017 to 2019, the conduct and the question the provider, you all should ask yourselves, is whether the conduct ended at the time before or right at when the OMIG audit period ends. But if the practice continued and resulted in an overpayment that occurred outside the audit period, then in such case, providers should conduct reasonable diligence within the applicable look-back periods. For most providers, that's going to be 6 years, 10 years if you're a managed care plan, and determine if any self-disclosure is warranted. I think it's important to remember that retaining an overpayment that you knew or should have known can result in monetary penalties. I believe under state law on the administrative side that OMIG would be enforcing, it's up to $10,000 per claim. It could also result in referral to the Medicaid Fraud Control Unit, because I think under the False Claims Act, there's actions that Sherry, I think you could take. And important to remember that a person has identified an overpayment when that person has or should have, through the exercise of reasonable diligence, determined that they've received an overpayment and quantified the amount. Just a couple other quick reminders, and then I'll let Sherry add anything she thinks is important here. But if payments are made to a managed care plan or made by a managed care plan to the provider, then those payments should be self-disclosed to the appropriate plan. Fee-for-service overpayments can be disclosed directly to OMIG. And I think a critical thing to always remember, particularly from both my perspective and Sherry's, is never to underreport or minimize conduct when self-disclosing. Because certainly those are things that we would potentially look for. Anything on that, Sherry, you wanted to add?
Thank you, Mike. Just briefly to explain something about the character of the Medicaid money. The money retains its character no matter how many hands it goes through until it's spent. So, for example, a payment made to a managed care plan that you as a provider may see as an enrolled provider to the plan, it continues to be deemed a payment by the state's medical assistance program. And so therefore, you can't view it as money you only got from the plan. It's state, governmental, and federal money. And we have the right to recover that money, and the state can recover it both from the provider and from the managed care plan that paid you. And the managed care plan, if it does it that way, may be seeking return from you, but we are not limited to going directly to you to recover it. But it's still really the best thing to just self-disclose or to correct the practice. Thank you.
I'd like to just make a somewhat of a closing comment. I know self-disclosure will probably come up in the questions, but I want to acknowledge and thank the provider community for their participation. You know, we look at it two ways. It's the required thing to do, and it's the right thing to do. And as you know, and many of you were on the previous webinar walking through the process, the new abbreviated process. And I can tell you that you are very active in participating in the self-disclosure program, and we very much appreciate it. And I'll close with, if you have any questions on self-disclosure or anything else, but in particular on self-disclosure, because that's the topic around at the moment, please reach out to the unit. If you have a question about which type of self-disclosure it may be, abbreviated versus full. They're very, very welcoming and interested in helping through that process. So thanks for your participation with that. And I think at this point, Gabe, perhaps we could start entertaining some questions if we all agree. Thank you.
Absolutely. And let me first say extend a warm welcome to all of you that have been on this webinar and have had the chance to hear from our two esteemed guests. I want to thank them personally, as well as their offices, for their willingness to participate in this interactive panel discussion. It's not always the case that we're able to bring governmental actors together in the nature of interchange that we're trying to engender through today's dialogue. And so we're very much grateful again to Michael, to Sherry, as well to Bill for the time that they have taken and for the broader contributions of the OMIG and others who have participated and are proceeding for webinars that have come before today's. And as Bill noted, we want to move now into a few questions and answers. Let me remind you all, though, for those who are unfamiliar with me, I'm Gabe Oberfield, Senior Counsel with Bond, and I focus in my practice within health and long-term care, working with a significant cohort of organizations that receive those Medicaid dollars that Sherry was describing just a moment ago. And it's our honor to help all of you as you navigate the various requirements and responsibilities as you do your good work in the service of New Yorkers. And with that noted, we will certainly take the additional questions that you have through the Q&A function that you see at the bottom of the webinar screen. You can also always follow up with us after the webinar, because as has been the case in previous iterations, and as Jackson noted at the top of today's conversation, the end of this hour that we have is not the end of the discussion. We will make sure to get questions answered as they are posed to the best of our ability. So to begin, let me ask a question of our panelists. It might make sense to direct this one to Mike, although of course, both of you, please feel free to jump on in. But with regard to an OMIG audit, Mike, you alluded to this a little bit in your comments earlier, but could you elaborate, please? What are the responsibilities that a provider has to go back deeper into a period that goes beyond that specifically around which your office is inquiring? You had mentioned, for example, 2017 to 19, but you want to look under and around that timeline if you have an expectation that the actions may not be so time limited. but if you could kindly just talk a little bit further about what that might look like, I think that'd be a great place to start, please. Thank you.
Sure, I think that, and this came up specifically when Medicare was promulgating its regulations on this same requirement, because there's corresponding requirements on the Medicare side to the Medicaid program. And sort of some extensive questions around what's a provider's obligation if there's an audit there's an audit by state or federal government, it finds an overpayment, what's the provider's obligations with respect to that? And I think from New York's perspective, if we conduct an audit, the audit period is for a set period of time. We don't expand our audit periods in our audits to identify all overpayments necessarily resulting from the conduct. Is for a set period of time. And certainly where providers are required to have compliance programs and be conducting their own internal auditing and review, I would say there's an expectation that if again, it has directly tied back to the overpayment that may have been identified in OMIG's audit. If the conduct that gave rise to that continues beyond the scope of OMIG's audit into future years, then I would suggest that providers are well served to look into that and make any self-disclosures, one, to take the corrective action to reduce the liability in the future and address it through the self-disclosure program, rather than waiting for a subsequent audit to come in and find the exact same issue. Again, one thing I'll just add to that is, and the federal sort of response on this addresses it too. If the provider disagrees with the finding and is pursuing its rights through, for example, an administrative hearing, then that obligation isn't necessarily immediately triggered until the overpayment determination is adjudicated through the administrative process. But at some point you get to a final determination as to whether there was an overpayment or not, and that might trigger then some obligation on the provider side to conduct reasonable diligence to look into the scope of the issue and if it goes beyond the audit.
Thank you, Mike. That's very informative, and I appreciate the caveats you added at the end concerning ongoing inquiries that may affect the timing of that additional review. That's all very instructive. And I'm wondering, Sherry, if there are analogous issues that you see or otherwise appreciate in reviews that your office is conducting. Would you, to ask the question specifically, take an approach as Mike prescribes, or better put, would you encourage a provider to do so if working on an issue that may, in its understanding, extend beyond the specific temporal period that you're looking into as an office?
I'll say we're appreciative if we're conducting an investigation and the provider is transparent and says, not only do we see there's a concern for the period you're looking at, but we see the concern for another period too. And that certainly will be appreciated and, taken into account when we're evaluating what is appropriate for the remedy and the recovery. And also, hopefully it's not going to elevate to criminal prosecution, but at times it does.
Thank you very much. In the spirit of your comments earlier, that is all consistent. That cooperation in the lowercase c sense of that term is very much appreciated by your office as well as the OMIG in order to resolve as efficiently as possible issues that may be uncovered and understood. Let me shift to a different question. With regard to self-disclosure, which is addressed under the OMIG protocols that Mike and Bill both referenced in their remarks, what nature of interchange, or better put, what nature of accord will the OMIG, or rather will the Medicaid activities within the Attorney General's office under MFCU afford to what it is that the OMIG may have learned through a self-disclosure process? Putting it another way, what is the nature of information that would be shared, notwithstanding some of the statutory and regulatory requirements that Mike referenced in his comments, and what would be, on the other hand, hands off and not shared as between your offices as a matter of course when a self-disclosure is undertaken?
Mike, do you want to go first?
Well, I think that, as I said, OMIG and the Medicaid Fraud Control Unit do coordinate with one another. If in the course of a self-disclosure, we came across any behavior that we read as being potential fraud that would trigger our obligation to refer that to the Medicaid Fraud Control Unit. We are not, just as the Medicaid Fraud Control Unit is not limited by OMIG's action, OMIG, we can't waive their authority to act, and in turn, they can't waive our authority to take action either on the administrative side. But certainly, if we uncovered something, we would have an obligation to refer it. I think that's not very common. But certainly if they had an active investigation, and as contemplated both in the statute and the regs, it really wouldn't be appropriate to resolve it through the self-disclosure program if the provider is aware that they're under investigation by Sherry's office. And we would share any information that we received from the provider with the Medicaid Fraud Control Unit as required by law.
And I would add to that, it's not in any way exclusive to self-disclosure, but I want to make it abundantly clear that what we don't want out of this conversation is to create any chilling effect on a provider's eagerness to participate in self-disclosure. Any instance where we determine upon our review, whether it's an audit, compliance review, self-disclosure, or any other allegations that we would define as, credible allegation of fraud, as Mike spoke to, it's the referrals take place. I think it's, as Mike said, it's can be a rare occasion, but it can happen. But the participation with compliance reviews, self-disclosure, the ongoing communications through the audit process are vital for our work and for your work. So I just want to reiterate that again, getting back to my earlier point about this is a collective effort. It is very much that. It's in everyone's best interest for the health and welfare of these recipients that we see it that way. That's in this spirit is why we're here today. So thank you.
Bill, thank you for that overarching point. Certainly, we agree in not just this conversation, but in the series that we've hosted now going back for previous iterations. The nature of this engagement has really been about ensuring information is in the field for those providers of services and programming in the Medicaid ambit, and we recognize that as a matter of course, having this information transparently available is helpful in the way in which you approach those in the audience, that is your operations. And so continuing in that spirit, which again, thank you, Bill, for underscoring. Sherry, I wanted to return back to a comment that you made a moment ago where you, in the context of discussing the period by which a matter might be reviewed, if there was information that suggested where a provider might suspect that a particular type of conduct extended beyond a temporally limited period that your office was focused on. You mentioned further that there would be potentially factors such as that, voluntariness that your office would consider in the ultimate disposition of matters. And so with that context in mind, I'm wondering whether there is a standard approach to how your office is, approaching repayment? Is it typically repayment on its face that your office is seeking? Are there typically, if not as a matter of course, penalties attached to whatever determination your office issues after it has concluded its activities? Or are there matters of discretion that you can employ? Knowing that, again, you're not speaking about any specific matter here, I'm just asking in general terms.
Really think it's discretionary based upon the individual investigation and the findings. And as I said before, taking into account the cooperation level of the provider.
Okay, that makes perfect sense, and thank you for underscoring that. And let's talk about a slightly different aspect of what it is to think about offices working both independently and as otherwise required collaboratively. Under what circumstances, if any, and this is really a question to both of you, would it be recommended that a self-disclosure activity point to federal authorities, specifically U.S. Department of Justice, Office of the Inspector General? We may have providers that, in effort to do the right thing, as it were, may see it as potentially appropriate to be affirmatively in touch with those with such an office. And I'm wondering whether you have specific thoughts on that, notwithstanding, Mike, your earlier comment that you each have independent authority as offices, presumably, so does DOJ. But I'd be interested in your perspective on that, because again, there's a multi-jurisdictional approach to some of these issues.
Yeah, I would certainly say that legally speaking, the obligation is to report and return it to the state, the department, OMIG. There may be situations, particularly if Medicare overpayments are also involved, then there's certainly HHS OIG has its protocols for how to return those overpayments. And certainly I would think that, again, under whether it's DOJ or OIG, there would have to be some ultimate circle back to the state to address the Medicaid portion and the returning of that. I probably the most likely reason why you'd want to go to DOJ would be if what you have is fundamentally suspected criminal activity, but I'm not sure I'm necessarily the best to speak to that. I don't know, Sherry, if you have anything additional or different from that.
MFCU does have certain obligations that are identified in 42 CFR 1007 as to when it must make referrals to federal agencies. It's possible we're already doing an investigation and working jointly with DOJ. DOJ may be more focused on the Medicare portion. A provider may be engaged in billing two separate healthcare programs. So, I would encourage you to check obligations to refer directly to HHS OIG. Obviously, MFCU does criminal investigations. They may also do it. They also do False Claims Act investigations under the Federal False Claims Act. Thank you.
I'll just add.
Please, Bill.
Gabe, I'll just add, if I may. Folks often read about large cases. They call them fraud takedowns, at the federal level often, and that they're national in scope. OMIG is very often mentioned in some of those cases. And we do work closely with local, state, federal law enforcement, MFCU included. A lot of allegations we get, we as we're obligated to, we refer them. And, we very much appreciate the partnership that we have with law enforcement across the board. And so those activities will continue, but we are certainly engaged at all the levels where appropriate. Thank you.
Thank you, Bill. There's a question that came through the chat, which I think if anything, it's a clarification. And so, Mike, I'll point to you on this. You had, in your earlier comments, mentioned the importance of working with a managed care plan if the funds flow through that managed care plan to the provider. The provider in this hypothetical is asking whether there needs to be an independent reporting to the OMIG if there's also reporting to the managed care plan, as generically stated here in the question. So Mike, with that background in mind, I guess the question is, does this provider need to double report, in this hypothetical?
No, if the provider has self-disclosed or reported and returned the money through the managed care plan, then that provider has met their obligation. The plan has, so no separate reporting by the provider to OMIG is necessary. The plan under its contract with the state has separate reporting requirements it needs to make with respect to overpayments that it identifies and recovers from its network providers.
Great, thank you. Bill?
I would add, I believe this was raised in previous webinars, and there's information on our website in the event where a plan may not be responsive to a self-disclosure. There's guidance on what to do in that instance. I just wanted to remind the folks of that. So thank you.
Yes, and I also wanted to note, in keeping with questions that have been previously posed, there was another query about requirements for self-disclosure processes as they relate to accidental and transactional overpayments. We've had a full session that included content on the abbreviated self-disclosure process, which is archived on our website, and that would certainly be informative. And so we encourage you and others to turn back to that. Noting that we're nearing the top of the hour, let me say to our panelists, thank you very much for the time you have taken. I found this to be incredibly informative, and it's hopeful that our viewers have also walked away with actionable content. And I wanted to, in closing remarks, take a few moments just to extend thanks once more, both to the Office of the Medicaid Inspector General, as well as to the Attorney General's office and MFCU specifically, and to our speakers today, Mike and Sherry, and to our moderator and jack of all trades, Bill Schwartz. We thank you very much for all of your involvement. We also wish to remind all of you that the content from these webinars, as I've mentioned in passing, is archived on our website, bsk.com, as Jackson mentioned at the top of this program. Further, we expect to answer any question that might have come in through the chat that we have not otherwise attended to in follow-up. And we also do not expect this to be the conclusion of this collaborative series with the OMIG and otherwise with governmental agencies focusing on issues of healthcare compliance and audit. It is key to so much of what you as providers tuning in need to pay heed to in the day-to-day management of your operations and in service of the New Yorkers who are your clients, patients, residents, etc. We know that this information is critical, and we want to ensure that we get it out to you in timely fashion. So we ask you please to look in your email inboxes for summary of today's dialogue. In email, you'll be able to find a link to this recording of the program and further information concerning the previous 4 programs. Moreover, as we move deeper into the fall, please expect to see invitations from us, for additional program content within our ongoing series. More to be determined as we progress into this season. But please trust we at Bond are very willing to be of support to you on questions concerning healthcare compliance and audit. It is a core part of our practice, and we have a team at the ready to be available and otherwise, we hope, useful in navigating questions that you may ultimately be contending with in the operations of your businesses. And so with that, we want to once again thank all of the speakers, and we look forward to your continuing participation in this series. And for now, we say goodbye and we thank you for your time.
Thank you.
Thank you, Gabe.
Thank you very much.